questions of like, who is the clerk of the district clerk employed by it? Now, the bill might not specifically speak to that. And that's a question that perhaps the Ethics Commission is going to have to resolve. There may be examples given to you which don't fall into one of these categories. And no bill is ever going to be perfect in that respect. Okay, substantial interest. I think that's pretty self-explanatory. You have a controlling interest. You own in excess of 10% of the voting interest or $25,000 fair market value. You have a participating interest.
You said participating interest, either direct or indirect, is where you share stock, otherwise whether or not voting rights are included.
What it is a participating interest in the profits, proceeds, or capital gains of the business entity in excess of 10%. Now, if they start throwing hypos out at you, like if I own some, you're just going to have to say that, okay, we haven't thought about every single situation. Give me a minute, and I'll have to go through the definition.
Exactly.
Any person that is required to file the statement may request an extension for 60 days. It's mandatory if the request for extension is received before the filing deadline. You may get only one extension.
Is this true when you're a candidate too?
No, it is not true for a candidate.
Once I file, like this year if I file, when do I have to, and then I show how much I made? Yeah.
Okay, you don't file it again till the next year.
That's what I say, do I have to file it again? Showing the same assets again?
Yeah,
You have a whole new
because
statement.
we got that word held in there.
Are you going to lead the floor discussion tomorrow, or is Nugent going to lead the floor discussion?
It's not known at this time. If Nugent decides to go with us, he'll lead the floor discussion. If he decides not to, then I'll lead it.
Liz, y'all were in there in the group when you were preparing these amendments and everything. Do you think that Jim understands it sufficiently to explain it just like you're explaining it to us now? Do you think he understands?
Today on House Bill number 1 as it came out of the committee. The explanation I'm going to give you here deals with what is commonly known as the Ethics Bill. This is the bill that sets up the prohibited acts which you may not do as a state official, and sets up a financial disclosure section for certain public officials in the state of Texas. All right, so the subcommittee's bill, which was thought by that subcommittee to be a good bill 28 hours ago, it was laid on our desk yesterday morning at 9 o'clock. Mr. Nugent, you mentioned earlier that some state officials fell under the prohibited acts portion of the bill. Now that's the stuff that can put a fella in the penitentiary. Is that right, Mr. Nugent? That is correct. All right. Would you, as author of the bill, tell us which public officials, which employees of the state of Texas are taking a chance on going to the state penitentiary if this bill passes? Under the provisions of the bill. No, I could not tell you specifically by name.
No, sir, I don't expect that. I mean, does it get people like school teachers teaching kindergarten in Port Arthur, Texas?
You've got this definition of public office, civil position of trust. Anybody who meets that test is subject to prohibited acts. County, state, city. All right. The only person subject to disclosure are people who meet, again, this definition of public office or civil position of trust, who additionally make $12,000 a year and who are state employees.
And state officers, all state
And
employees.
state officers. All right. As I understood the Attorney General's objection on the disclosure part of it was we had a $15,000 figure in there. And they were saying, you can't require somebody making $15,000 or above in state government to file when you're not requiring somebody $15,000 or below.
We believe the Supreme Court would overturn invasions of the right of privacy if the selection of those whose privacy is to be invaded is not based on the relation of their function and authority vis-a-vis the proper discharge of public business and the exercise of governmental power. Okay. So what we're saying is, here is their discharge of function of its governmental powers. And another clarification is the $12,000. I think the $12,000 weakens it, but it doesn't fly in the face of this amendment. Okay, school board members would be covered by the prohibited acts.
Yeah.
Because they are holding a position under the state, which is not
They're
of
not
the
making
state.
$12,000.
That has nothing to do with prohibited
Alright.
acts, Jim.
I don't understand.
You have got to get those two things just emblazoned in your mind. 12,000 is only disclosure. Ain't no school district created by statute.
I thought they all were. I thought all
They're
of
not created by
Dallas
statute.
Independent School District's created by statute, by state statute. Because we're about to amend it right now by requiring how they run and everything.
Do you seriously think that a janitor or a public school teacher would be covered by the definition of public office or civil position of trust that's in the bill?
Mr. Bales, would you turn to section 7 of the bill? No officer or employee of a state agency. All right, now let's go back and see the definition of state agency that you blessed us with in this bill. State agency. Any department, commission, board, agency. I find it quaint that you define agency in terms of agency, but it's been done. Or office, that is within the executive, legislative, or judicial branch of the state government, created by statute.
It doesn't say anything about schools.
Well, I'm not finished. You have to go back to section 7, Mr. Bales.
Mr. Doyle, you cannot
Exactly.
say that a janitor exercises any of this discretionary authority that's contained in that definition.
Mr. Bales, in section 3, section 4, section 6, section 7, you can, we've gone through this earlier in the day, and I'm just too tired to go through it again. It's been pointed out, it's been admitted by the authors of the bill.
No, it
that
has not been admitted by the authors of the bill. I beg your pardon. You've been misinterpreting all day who's covered by this bill, and I'm trying to keep you from misleading the members of the House.
I did not specify which provisions of we've been through this 3 times, which provisions of your bill apply to all of these thousands of people. If you think for 1 minute that this bill does not apply to the college professors in the College of Texas, you don't understand the bill.
Well, I beg your pardon.
That's
If
20
you think for 1 minute that it applies to a pure professor,
You know, I really and truly think it is significant that the 3 of us, you know, all 3 freshmen, who never had anything to do before, don't know much about this, and are given the responsibility for watching over some of the ethics of some of the guys who've been down here for so long and trying to cure some of the problems that, you know, that Sharpstown brought on, you know. Don't you think?
yeah.
I think it's pretty good. I'll tell you one thing, I hope nothing happens to change that.
The opponents of this bill might also think it's significant.
Why don't you file it with the Ethics Commission, what public access is there to it?
It's public.
Total. The total.
No, the investigation part of it isn't public until the hearing.
I'm not talking
But
about
the
that.
disclosure is totally public.
When you disclose all your assets, it's totally public.
Anybody can come in and get a copy of it.
I'd like to have your attention because the amendment I am now offering makes the most substantive change in the bill of any that has been offered so far. Now, essentially under this act, as it is now written, if enacted, you would have to file 2 separate documents. One of them which states the interest you might have in any business entity which is licensed by a state agency. This amendment does not touch that provision. It would remain the same. But with respect to the financial statement, essentially what it does is it requires anyone filing a statement under this act to put it in a sealed envelope with his name, his address, a statement of the fact that it is his financial statement, his office, and the term of his office. that goes in a sealed filing cabinet and is not opened unless and until the Ethics Commission by majority vote decides that the matters contained therein may be relevant to an investigation or a complaint.
Don't you think that you're offering a serious impediment to a finding of probable cause by leaving that envelope sealed? Pray tell, how else are you going to find out?
Pardon me?
How are you going to establish probable cause with that envelope still sealed?
I don't think that the materials there are plenty of ways to find probable cause. You're not just going to willy-nilly accuse something. You're going to have some idea of whether he has committed any violation or anything else. If you've got enough facts, you can go to court. They can order that those documents be brought out. This act, if you have read it carefully, is very punitive, particularly to those people who do not have a large material estate. And let me illustrate exactly what I'm talking about. Let's suppose that a member of this House has a business that he's opened. He's struggling to make it a success, and his wife is back home trying to run it while he's sitting here. I believe it does.
Does your amendment in any way lessen the financial filing or financial disclosure and ensure that the confidentiality of this information is truly kept confidential?
I believe it does.
Is it not possible that if we make the documents public, that what we're going to get into on the other hand, the other side, is campaigns that are not based on issues, not based on...
I suppose we finally will come down in a debate that is this long with an amendment that is extremely important and one that does make a tremendous amount of difference. Now, and speaking of the question of invasion of privacy, back during the term of office that Thomas Jefferson was President of the United States, he made this statement: when a man assumes a public trust, he should consider himself public property. Members, disclosure does not attempt to define the rights or wrongs in any situation. It makes no judgment.
The authors of the bill, in drafting this bill, had in mind as one of the key provisions public disclosure of assets. We tried to write into this law to prevent disclosures of assets that bear